December 26th. That's your deadline. After that date, the 90-day rule kicks in, and thousands of green card holders flying back into the U.S. are going to get pulled into secondary inspection with no idea why. 3 months abroad used to be safe. Not anymore. Your permanent residence just became way less permanent, and most immigrants have absolutely no clue what's coming. If you're interested in this topic, hit the like button, subscribe, and type "interested" in the comments, and I will give you a heart. I was at LAX last week, Terminal B. Watched a woman in her 50s get her green card taken right there at the immigration counter. Just handed over her card like she'd done 100 times before, smiled at the officer, ready to go home. 30 seconds later, her face went pale. The officer called someone over. 2 more uniforms appeared. She got escorted to a side room, and I didn't see her come out. Her husband was waiting at baggage claim, holding flowers. I know because I walked past him an hour later, and he was still standing there, confused, checking his phone. That scene? It's about to become a lot more common. And if you're a green card holder who travels internationally, you need to understand exactly why that woman's life just fell apart and how to make sure it doesn't happen to you. Here's what nobody's telling you clearly enough. Your green card isn't actually permanent in the way you think it is. It's conditional, always has been. There's this one massive requirement attached to it that most people don't fully grasp until it's too late. You have to maintain the United States as your primary residence, not your second home, not the place you visit when it's convenient, your primary residence, the place where your life is actually centered. And starting December 26th, the government is rolling out new screening technology and updated enforcement protocols specifically designed to catch people who aren't meeting this requirement. The old informal guideline that most immigrants have been following goes something like this. Stay out of the U.S. for less than 6 months and you're probably fine. Push it to between 6 months and a year and you might get some questions, but nothing catastrophic. Cross that 1-year mark and you're in serious trouble. That's what everyone's been operating under for years. That guideline? It's dead. December 26th kills it. The new threshold is 90 days, 3 months, that's it. Any absence from the United States exceeding 90 days will trigger enhanced review when you try to re-enter. Not might trigger, will trigger. The system flags you automatically. The officer sees an alert the second they scan your card. And now you're not breezing through customs on your way home. You're getting pulled aside for secondary inspection, where your entire immigration status is about to be interrogated. Let me be very clear about what this means practically. If you left the U.S. on September 1st and you're coming back January 15th, that's more than 90 days. Flagged. If you went to visit family in the Philippines in October and you're planning to return in late January, that's more than 90 days. Flagged. If you're working on a business opportunity abroad that's taking longer than expected and you've been gone since early November planning to return in February, that's more than 90 days. Flagged. The math is simple and brutal. And here's the part that's going to catch thousands of people completely off guard. It's not just about single trips anymore. The new system tracks cumulative time outside the United States, patterns of travel. If you're someone who splits time between countries, someone who travels internationally every couple of months for a few weeks at a time, the system is now calculating your total time abroad over the course of a year. Let's say you're a green card holder who does business internationally. You travel to Dubai for 3 weeks in March, you go to London for 2 weeks in May, you visit family in India for a month in August, you attend a conference in Singapore for 10 days in October. Each individual trip seems fine. None of them hit 90 days. But added up, you've been outside the U.S. for nearly 3 months total over the course of the year. And that pattern creates a profile that says maybe you're not really living in America. Maybe you're living somewhere else and just using your green card as a travel document. That's what the new system is designed to detect. And when it detects that pattern, you get flagged just the same as someone who took one long trip. Now, I know what some of you are thinking. I'll just be careful. I'll explain my situation. I have legitimate reasons for traveling. And maybe you do, but here's what you need to understand about secondary inspection and how these interviews actually go down. When you get pulled into that room, you're dealing with Customs and Border Patrol officers who have seen every excuse, every explanation, every sob story 1,000 times. They're not mean people. They're not trying to ruin your life, but they have a job to do, and that job is to enforce immigration law. And the law is very clear. If you're not maintaining the U.S. as your primary residence, you've abandoned your permanent residence status. They're going to ask you questions, detailed questions. Why were you outside the U.S. for so long? Where exactly were you? What were you doing? Do you have a job in the United States? Where do you live? Do you own property here or are you renting? Where does your family live? Did you file U.S. taxes last year as a resident or non-resident? Do you have a driver's license? Is it current? Do you have bank accounts in the U.S.? When's the last time you used them? These aren't casual conversation questions. These are interrogation questions designed to determine whether your life is genuinely centered in America or whether you're essentially living abroad and occasionally visiting the U.S. Every answer you give is being evaluated. Every pause, every hesitation, every inconsistency gets noted. And here's where people make catastrophic mistakes. They get nervous, they start talking too much, volunteering information that wasn't asked for. They contradict themselves, they admit things without realizing how those admissions sound. Well, I've been staying with my parents overseas because they're getting older and need help. Sounds reasonable, right? To you, it sounds like you're being a good son or daughter. To the immigration officer, what they just heard is, I've been living in another country taking care of family there, which means that that's where my primary residence is, not here. Or someone says, I'm working on a business opportunity abroad and it's taking longer than expected to get it set up. Again, sounds reasonable to you. You're an entrepreneur, you're building something, you're still committed to coming back to the U.S. What the officer hears is, I've established business operations in a foreign country, I'm actively working there, my economic ties are there, not here. Or here's a common one, I'm renting out my house in the U.S. while I'm away to cover the mortgage. You think you're being financially responsible. The officer hears, I don't actually live in that house, I've converted it to income property because my life is elsewhere. Every single one of these answers can be used as evidence that you've abandoned your U.S. residence. And if the officer determines that you have, they have the authority right there on the spot to confiscate your green card. They don't need a judge. They don't need approval from anyone else. They can take your card, give you a notice to appear for an immigration hearing, and send you into the United States as a visitor while you fight to get your status back. Or they can refuse to let you enter at all and send you back on the next flight to wherever you came from. Both of these things are happening right now, and they're about to happen a lot more frequently after December 26th. Let me tell you about the reentry permit, because this is something every green card holder who needs to travel for extended periods should know about, but most people don't find out about it until it's too late. A reentry permit is an official document issued by USCIS that allows you to stay outside the United States for up to 2 years without abandoning your permanent resident status. It's like insurance for extended travel. If you have a reentry permit, you can stay abroad for the full duration it covers, and when you come back, you present it along with your green card, and the presumption of abandonment doesn't apply. Sounds perfect, right? Here's the catch. You have to apply for it while you're physically in the United States, before you leave. You can't apply from abroad. You can't apply after you're already gone for months. The application process requires you to submit biometrics, which means you need to appear in person at a USCIS office for fingerprinting and photos. The whole process takes several months from application to approval. So if you're planning a trip that's going to exceed 90 days, you need to be thinking about a re-entry permit at least 4 to 6 months before you leave, not the week before your flight, not after you're already overseas realizing you might need one. By then, it's too late. And here's something else about re-entry permits that people misunderstand. Having one doesn't mean you can live abroad permanently and just pop back into the U.S. occasionally. It protects you from the presumption that a long absence means you abandoned your status, but officers can still question your intent and your ties. If you have a re-entry permit, but you've clearly established your primary life in another country, you can still lose your green card.
The permit buys you time and legal protection, but it doesn't eliminate the fundamental requirement that the U.S. be your primary residence. Now, let's talk about maintaining U.S. ties actually means in practical, provable terms. Because I live in America isn't enough when you're sitting in secondary inspection trying to convince an officer not to take your green card. You need evidence, documentation, proof that your life is genuinely centered here. First, you need a real U.S. address, not a mail forwarding service, not your cousin's house that you've never actually lived in, a real address where you actually reside when you're in the country. If you own property, you need to show the deed, property tax payments, homeowner's insurance, utility bills in your name showing ongoing usage. If you're renting, you need a current lease agreement with your name on it, rent payment records, again, utility bills showing you actually live there. Officers know the difference between an address you use.
What if you're studying abroad? Here's where it gets tricky, and this is a situation where a lot of young green card holders get themselves into serious trouble without realizing it. If you enroll in a full-time academic program in another country, you're essentially telling immigration authorities that you've made that country your primary residence for the duration of your studies. Think about it from their perspective. You're attending university in Germany for 4 years. You're living in student housing there. You're probably working part-time there. Your social life, your daily routine, your entire existence for those 4 years is centered in Germany, not the United States. That's textbook abandonment of residence. Now, semester abroad programs or short-term exchange programs, those are different. If you're enrolled in a U.S. university and you do 1 semester in Spain as part of your degree program, that's clearly temporary and tied to your U.S. education. You can document that you're returning to complete your degree in America. But enrolling as a full-time student in a foreign university for multiple years, that's going to be extremely difficult to defend as maintaining U.S. residence. If you're in this situation or considering it, you need to talk to an immigration attorney before you commit to that foreign university. There might be ways to structure it, maybe maintaining part-time enrollment in a U.S. program simultaneously, maybe coming back to the U.S. every few months, but it's risky and you need professional guidance. What if you're caring for elderly parents abroad long-term? This is probably the most heartbreaking scenario because it's completely understandable from a human perspective. Your parents are aging, they need care, they're in your home country, and you're the one who needs to be there for them. I get it. Immigration law gets it too, in a sense. But here's the brutal truth. There's no specific exception in the law for taking care of parents. The law doesn't say you can abandon your U.S. residence if you have a good reason. The requirement to maintain primary residence in the U.S. doesn't have a compassionate exception clause. If you know you're going to need to spend extended time abroad caring for parents, apply for a reentry permit before you go. It gives you up to 2 years of protection. If the care situation extends beyond 2 years, you're facing a very difficult choice. You might need to choose between keeping your green card and being there for your parents. That sounds harsh, and it is harsh, but it's the reality of immigration law. Some people in this situation decide to let the green card go because family comes first. Others bring their parents to the U.S. if that's possible. Others split time, spending a few months abroad, then coming back to the U.S. for a few months, back and forth, which is incredibly difficult but keeps their status intact. There's no easy answer here, but you need to go into it with your eyes open about what you're risking. Now let me tell you about something that's changing on the enforcement side that most people have no idea about. The level of data integration and information sharing between government agencies has increased dramatically over the past few years, and it's about to get even more sophisticated after December 26th. USCIS, Customs and Border Protection, the IRS, the Social Security Administration, even state DMV databases, they are all talking to each other now in ways they weren't before. What this means practically is that immigration officers at the port of entry have access to information about your tax filing status, whether you're earning U.S. income, whether you've got a valid U.S. driver's license, whether you're claiming benefits that suggest you're living abroad. If you filed your taxes as a non-resident, they can see that. If you claimed foreign tax credits indicating you're paying taxes as a resident of another country, they know. If you haven't had any U.S. income reported to the IRS for 2 years, that's visible. If your driver's license expired and you never renewed it, they see that too. All of this information creates a profile of whether you're genuinely living in the United States or not. And the new system that launches December 26th uses this integrated data to automatically flag people whose profiles suggest they've abandoned residence. This isn't an officer making a subjective judgment call anymore. This is an algorithm that says this person hasn't filed U.S. taxes in 2 years, has no reported U.S. income, been outside the country for 180 days of the last 365, and their driver's license expired 14 months ago. Flag for secondary inspection. It's systematic, it's data-driven, and it's much harder to slip through. The days of assuming nobody's really checking, nobody's really adding up all your trips, nobody's really cross-referencing your tax status with your travel patterns, those days are over. Let me walk you through exactly what happens when you get flagged under this new system, because understanding the process might help you avoid panic if it happens to you. You land at a U.S. airport. You go through the immigration line, you hand your green card and passport to the CBP officer. They scan it. Normally, this takes about 30 seconds and you're waved through. But this time, their computer screen shows an alert. Maybe it's a red flag icon. Maybe it's a code. Whatever the visual indicator is, it tells them you need additional screening. The officer's demeanor changes. They're not rude, but they're no longer casual. They ask you a few quick questions. How long were you outside the United States? What was the purpose of your trip? Where do you live in the U.S.? Your answers to these initial questions matter enormously. If you say something like, "Oh, I've been visiting family for a while, I'm not really sure exactly how long," that's a terrible answer. It suggests you're not tracking your time outside the country, which suggests you're not concerned about maintaining residence. If you say, "I was gone for 105 days visiting my parents who needed help after my father had surgery," that's a much better answer. It's specific, it acknowledges you know the time frame, it provides context. But either way, if you're flagged in the system, these initial questions aren't going to resolve it. The officer is going to say something like, "I need you to step over to that area for additional processing." They point to secondary inspection. Your heart sinks. You know this isn't good. You gather your bags and you go to the secondary area. It's usually a separate room or a cordoned-off section. There are rows of chairs, usually bolted to the floor. There's a counter with officers behind it, each one working through cases. You sit down and you wait. This can be 30 minutes, it can be 3 hours, it can be longer. You don't get to argue about it. You don't get to demand they hurry up. You wait until they call you. When they call your name, you go up to the counter. The officer has your file pulled up on their computer. They have your entire immigration history, your travel records, probably your tax information, everything. And now the detailed questioning begins. Tell me about your trip. Where exactly were you? Why were you gone so long? Do you have a job in the United States? Who's your employer? What's your job title? Where's their office located? When did you last work? Do you own property in the U.S.? What's your address? Do you rent? Can you show me your lease? When does it expire? Are you living there now or is someone else living there? Where does your family live? Are you married? Where does your spouse live? Do you have children? Where do they go to school? Did you file U.S. taxes last year? Do you have your tax return with you? Did you file as a resident or non-resident? Do you have a driver's license? Is it current? What state? Do you have bank accounts in the U.S.? When's the last time you used them? Do you have bank accounts in other countries? Do you own property in other countries? Have you applied for citizenship anywhere else? Do you have another passport? The questions come fast. They're designed to build a complete picture of where your life is actually centered, and they're designed to catch inconsistencies. If you said you work for a company but you can't remember your job title or your supervisor's name, that's suspicious. If you claim you live at an address but you don't have any mail, bills, or any documentation showing you actually live there, that's suspicious. If you say you have a U.S. bank account but you can't remember the last time you used it, it suggests it's not really where you do your banking, which suggests your financial life is elsewhere. This is where having your documentation folder becomes critical. When they ask for proof of residence, you pull out your lease. When they ask for employment, you have your pay stubs. When they ask about taxes, you have a copy of your return. When they ask about your address, you have utility bills. The ability to immediately provide documentation shows you were prepared, shows you understand the requirements, and shows you have legitimate ties. It doesn't guarantee they'll let you through, but it dramatically improves your odds. Here's what can happen at the end of this interview. Best case scenario, the officer decides your ties are sufficient, your absence was justified, and you still meet the residence requirement. They stamp your passport, return your green card, and tell you you're free to go. You've survived secondary inspection. But they'll usually add a note to your file, and if you get flagged again in the future, the scrutiny will be even more intense. Second scenario, they're not satisfied, but they're not ready to make a final decision. They might let you enter the United States, but tell you that your case is under review. They might require you to report to a USCIS office within a certain time frame for additional questioning. They might tell you they're opening an investigation. This is a gray zone where your status is technically intact, but seriously at risk. You need an immigration attorney immediately if this happens. Third scenario, they determine you've abandoned your residence. Right there, they take your green card. They give you a form called a notice to appear, which is essentially a charging document saying you're removable from the United States. You're given a date to appear before an immigration judge. You're allowed to enter the U.S., but you're no longer a permanent resident. You're here on what's essentially temporary permission while your case goes through immigration court. This is catastrophic. Your work authorization is gone, you can't leave the country and come back, your entire status is in limbo until a judge makes a final. The underlying policy shift here is about redefining what permanent residence actually means. For years, the system operated with what you might call benign neglect. The rules were on the books, but enforcement was inconsistent. Lots of green card holders were essentially living abroad with occasional visits to the U.S., and as long as they didn't stay away for more than a year at a time, they usually got waved through. The government knew this was happening but didn't have the resources or the political will to crack down systematically. That era is ending. The current approach is that permanent residence means exactly what it says. You're a resident. Not a visitor who comes occasionally, not someone who uses the green card as a convenient travel document while living somewhere else. An actual resident whose life is genuinely centered in the United States. And they now have the technology and the resources to enforce this understanding consistently. What does this mean for you personally? It depends entirely on your situation, your travel patterns, and your actual ties to the United States. If you're someone who lives in the U.S., works here, has family here, travels abroad occasionally for normal reasons like vacation or visiting relatives, and you're never gone for more than a few weeks at a time, these changes don't really affect you. You're exactly the kind of permanent resident the system is designed for. You'll go through immigration, they'll scan your card, you'll get waved through. No problems. But if you're someone who's been pushing the boundaries, someone who spends significant time abroad, someone who's been treating the 6-month guideline as a rule rather than a guideline, someone who's been maintaining minimal U.S. ties while actually living most of your life in another country, you're in the danger zone now. And December 26th is when that danger becomes very real and very immediate. Let me talk about a specific group that's going to be disproportionately affected by these changes. Retirees who obtained their green cards while they were working in the U.S. and then retired back to their home countries. This is extremely common. Someone immigrates to America in their 30s or 40s, works here for 20 or 30 years, gets their green card, builds a life, but never quite feels completely at home. Their extended family is still in their country of origin. The cost of living is lower there. Healthcare might be better or cheaper. They speak the language, understand the culture. So when they retire, they move back home. But they keep their green card because it gives them flexibility to visit children or grandchildren in the U.S., or because they receive Social Security benefits, or because they want to keep their options open.
These retirees have been living in this gray area for years, coming back to the U.S. every few months to reset the clock, staying for a couple weeks, then going back to where they actually live. Under the new system, this pattern is going to get them flagged immediately. The algorithm is going to show repeated entries, followed by short stays, followed by long absences. It's going to show no U.S. employment because they're retired. It's probably going to show they're claiming Social Security, which technically doesn't require U.S. residents, but does require them to have been residents when they qualified. If they're receiving Social Security payments to a foreign bank account, that's visible in the data. If they're filing U.S. taxes as residents but reporting no U.S. income and claiming foreign housing, that creates a profile of someone who's retired abroad, not in the U.S. These individuals are going to start losing their green cards in large numbers after December 26th unless they make immediate changes. The change they need to make is actually moving back to the United States as their primary residence, or accepting that they need to give up the green card. There's really no middle ground under the new enforcement regime. Another vulnerable group is people who got green cards through marriage but later divorced or separated from their U.S. citizen spouse. If you're in this situation and you've been spending a lot of time abroad, maybe returning to your country of origin because the relationship that brought you to the U.S. ended, you're at high risk. Immigration officers are going to look at your case and see that the family tie that brought you here no longer exists, and you're not maintaining strong, independent ties to the U.S. They're going to question whether you should still have permanent resident status at all. The legal answer is yes, if you obtained your green card legitimately and removed conditions if applicable. The divorce doesn't automatically affect your status. But if you've abandoned residence by living abroad, the divorce becomes context that makes your pattern look even worse. My advice if you're in this situation is either to commit to genuinely living in the United States and accept the limitations that come with that, or you can work toward citizenship so you have more freedom in the future. You can decide that your ties to your country of origin are stronger than your ties to the U.S. and voluntarily give up your green card. You can try to find middle ground with careful planning, reentry permits, and meticulous documentation, but what you can't do is continue operating the way you might have been operating for the past few years and expect that to work after December 26th. The enforcement environment has fundamentally changed. So here's what you need to do right now, today, before December 26th arrives. First, calculate your time outside the United States over the past year. Add up every trip. Know exactly how many days you've been abroad cumulatively. If it's approaching or exceeding 90 days, you need to be prepared for questioning next time you return. Second, gather all your documentation proving U.S. ties. Create that folder I mentioned earlier with copies of everything: lease or mortgage, utility bills, tax returns, pay stubs, bank statements, driver's license, everything. Keep it with you when you travel. Fourth, if you have upcoming travel that will take you outside the U.S. for more than 90 days, either cancel or postpone those plans or apply for a re-entry permit right now before you go. Don't wait. The application takes months. Fourth, if you're eligible for citizenship or close to eligible, make that your top priority. Start gathering documents, studying for the test, preparing your application. That's your path to security and freedom. And here's something crucial. If you have a history of extended travel, but you haven't yet applied for citizenship, you need to establish a clean pattern of residence for at least the year before you apply, ideally longer. USCIS reviews your travel history as part of the naturalization process. If they see you've been spending more time abroad than in the U.S., they can deny your application on the grounds that you haven't maintained continuous residence. So if citizenship is your goal, you need to commit to actually living in the United States full-time for the period leading up to and during your naturalization process. No extended trips, no pattern of frequent travel, just solid, documented presence in the U.S. Let's address the financial and practical implications of all of this, because losing your green card isn't just an immigration status issue. It affects every aspect of your life in America. If you lose your permanent resident status, you immediately lose your work authorization. You can't legally work in the U.S. If you have a job, you have to quit, or you'll be working illegally. Your employer is required to terminate you because they can't keep someone on the payroll who doesn't have work authorization. If you own a business, you can't continue to run it from within the U.S. without status. You lose access to most government benefits. Social Security benefits that require residence are gone. Medicare might be affected. Any state or federal assistance programs are immediately ineligible. You lose your ability to travel freely. You can't leave the U.S. and come back while your case is pending unless you get special permission. And if you do leave, you might not be allowed to return at all. Your housing situation becomes precarious. If you're renting, you might be able to continue your lease depending on your landlord, but you can't sign a new one without legal status. If you have a mortgage, you still own the property, but if your income disappears because you can't work, you can't make the payments. Your children, if they're U.S. citizens, can stay in the country, but now you're facing the devastating choice of being separated from them or taking them with you to a country that might not be their home. The cost of fighting a denaturalization or abandonment case runs into tens of thousands of dollars. Immigration attorneys who handle these cases charge anywhere from $300 to $500 per hour or more. The total cost for representation through the entire process can easily exceed $30,000 to $50,000, and there's no guarantee you'll win. Even if you have a strong case, even if you have good ties and good documentation, immigration judges have broad discretion. If they decide you abandoned your residence, that decision is very difficult to appeal. So the financial hit isn't just losing your ability to work, it's the cost of legal defense, the cost of potentially relocating to another country with little notice, the loss of equity and property you might have to sell quickly, the disruption to your entire financial life. Compare that cost to the cost of actually maintaining genuine residence in the United States, or the cost of properly planning your travel with reentry permits and documentation. The difference is enormous. Protecting your status proactively is infinitely cheaper than trying to recover it after you've lost it. Now let me address the emotional and practical aspect of all of this, because I know a lot of you watching this are feeling anxious, maybe scared, maybe angry. You worked hard to get